in yet another 6-3 decision today, once again along ideological lines, the Supreme Court ruled in favor of a Washington State public high school football coach who was fired by his district for leading prayers at the 50-yard line after games. In the majority opinion, Justice Gorsuch ruled the firing was unconstitutional because both the free exercise and free speech clauses of the First Amendment protect expressions like this. This is just one of a number of recent rulings that appear to weaken longstanding legal precedent for the separation of church and state. Just last week, the court ruled a taxpayer-funded private school tuition program in Maine cannot exclude religious schools, just the latest in this trend of allowing greater and greater state involvement in religion. I'm joined by the legal director of the ACLU of Massachusetts, Matthew Segal. Matt, it's good to see you. Thanks for being here.
Thank you, Jim.
You know, starting with this main thing, we're talking about what impact these decisions have in Massachusetts. Weren't we one of the 37 states that had a constitutional prohibition on public aid, meaning taxpayer funding, for schools to go to religious schools? Am I not right about that?
Well, we do have in Massachusetts something called an anti-aid amendment. Right. But one of the things that I think is important to understand about the Maine case, but also the football prayer case, is that the facts of the cases that the Supreme Court decided might be substantially different from the facts that exist in Massachusetts.
How so?
So even though there was this program in Maine which was a tuition program based on the idea where private individuals are given assistance to attend private K through 12 schools, but so long as they weren't religious. Massachusetts is a little different. We don't have a program precisely like that. And nor do we have within such a program a law that singles out religious private education. So we're not handing, to my knowledge, we're generally not handing parents money to say you can use this money on a private school so long as it's not religious. And for that reason, it's not obvious that the pronouncements by the Supreme Court, as worrisome as they may be on a broad scale, are going to have an immediate impact in Massachusetts.
Well, that's somewhat comforting. Do you feel the same way about this kneeling at the 50-yard line? I have to say I'm a big fan of NPR because I work for a local outlet. But when I heard NPR reporting on this decision this morning, they said, you know, the coach invited players who wanted to pray with him. And when you're the head coach, who happens to be taxpayer funded, and you say, I'm going to pray, but you don't have to, that to me sounds like I would suggest you get here if you want to start in the game on Tuesday. Is that of limited concern to you too?
Well, I have a similar response. First of all, as a civil rights lawyer, but also as a parent, I have some doubts about the facts as they were characterized by the Supreme Court. I mean, my kids play sports. We all understand, and I think student athletes implicitly understand, that the optional stuff isn't truly optional. But what's important for purposes of understanding what the Supreme Court did to the law this morning is that the facts as articulated by the majority in the opinion are the facts that will determine what their legal pronouncements mean. So when they say, as they did in this opinion, there was no evidence of coercion, that means that people will be free in future cases to get a different result when they can establish that there was coercion. Now, in the dissent in this case certainly says, wait a second, those aren't the facts. The actual facts here are that there was evidence of coercion. But as construed by the majority, there's no evidence of coercion in this case. And so, like my answer to you, Jim, with respect to the Maine case, this might be another case that is not necessarily going to have a broad impact in say, Massachusetts, when there are situations where the coercion is obvious.
Yeah, but by the way, I'm comforted by this after the nightmare of virtually every other ruling. And I know you have deep concerns beyond our borders, but to I was going to say a layperson, I'm theoretically a lawyer, but not like your kind of lawyer. Isn't there de facto coercion when an authority figure like that says, feel free not to participate? I mean, I'll tell you, if I was on that team, I wouldn't feel free not to participate. Am I barking up the wrong tree?
Well, certainly what you're saying, Jim, is in line with what the dissent said. And I'm not here to tell you or any listener or viewer that everything's just fine and dandy at the Supreme Court. That is not what I'm saying. It's rough. And I'm not here to pretend either that this decision will have no impact on eroding or chipping away even significantly at the wall between separation between church and state. But what I am here to say is that if you're a parent out there, a student out there who really is being coerced, this decision does not tell you to just stay silent
Oh, I understand.
and not tell you to seek help. You can go and get help, and you should contact people.
And I only have 30 seconds left, but I know this is Nostradamus time. But based upon everything from Hobby Lobby on down, this is the direction that religion, I was going to say, and guns, frankly, but religion trumps all with this court. Is that not a fair statement?
Well, one way to think about it is if the Supreme Court of the United States were an administrative body and its decisions were to come up for review before the Supreme Court of the United States, the Supreme Court might say that those decisions were not fair.
On that note, Matt Segal, it's good to see you. Thanks so much for your thoughts. I really appreciate it.
Thank you, Jim.